Good afternoon. My name is Nicole Parisi, General Counsel at the Association of Prosecuting Attorneys. APA is a private nonprofit located in Washington, D.C., serving prosecutors as well as their law enforcement and community partners. Thank you so much for joining our webinar today. Today's webinar, Remote Orders of Protection in Criminal and Civil Cases Involving Intimate Partner Violence and Animal Abuse, will highlight 3 jurisdictions who have rapidly moved to implement remote access to orders of protection in King County, Washington, Miami-Dade County, Florida, and Winnebago County, Illinois. During today's webinar, you will be able to submit questions for our speakers using the question box on the GoToWebinar toolbar located on the right side of your screen. While you may ask questions during the course of the presentation, we will hear from our speakers first and ask questions after. If you need additional assistance, please feel free to contact us directly at webinars@apainc.org. Additionally, later in the presentation, you will be asked to use the raise hand function that is also located on your toolbar. This webinar is made possible by the support of the Animal Legal Defense Fund. ALDF helps support APA's Animal Cruelty Prosecution Project that provides training and resources for prosecutors and allied professionals in prosecuting animal cruelty and animal fighting. Our Animal Cruelty Prosecution Project works closely with our Domestic Violence Prosecution Project in understanding animal cruelty is often a co-occurring crime to family and interpersonal violent crime. Additionally, perpetrators often use violence or threat of violence against pets to intimidate and control their victims. Many victims refuse to leave abusive situations if they have nowhere safe for their pets. Others who do get out but leave pets behind suffer additional stress and anxiety worrying about what will happen to them. One way to help these victims protect their pets is to ensure custody through the protection order process. So to get started, I want to introduce Laura Dunn, the Director of the Criminal Justice Program at ALDF. Laura leads a team of attorneys in assisting, training, and educating prosecutors, law enforcement, judges, veterinarians, and other key stakeholders throughout the country on animal cruelty services. So Laura is going to speak to you a little bit about the services that ALDF provides and how they can help you. Laura?
Thank you, Nikki, and thanks so much to APA and CCI for bringing together such a distinguished panel today. This is really such a timely and important topic, and we at the Animal Legal Defense Fund are really honored to be supporting today's webinar on some of the models of practice that we know will greatly impact how all of our listeners are dealing with these day-to-day issues of safety in their communities. We at the Animal Legal Defense Fund unfortunately see the link between violence toward human and animal victims play out in our daily work, and we know that these situations are only heightened by COVID. A little bit more about us. As Nikki mentioned, we are a national animal protection organization, and our criminal justice program works in a number of ways to provide resources to legal professionals for any animal cruelty case, or really any case involving an animal victim. So for law enforcement, prosecutors, judges, veterinarians, probation officers, any of those stakeholders in these cases. We provide in-person trainings, including our annual Animal Cruelty Conference that we co-present with APA, as well as remote trainings for your department that can really be tailored to your needs. We also know how busy all of your offices are with very full dockets, so we're really here and eager to help with any legal research, motion drafting on your cases. We also have funding available for things like forensic work for necropsies and assistance caring for seized animals. So in short, if there is an animal victim involved in your case, we are really here to help, so please don't hesitate to let us know how we can. So with that, I will pass it back over to Nikki.
Thank you, Laura. Next, I want to say thank you to the Center for Court Innovation for their partnership on this webinar and helping us get the speakers on board and to help facilitate this presentation today. So I'm going to pass this over to Robin Mazer, who will facilitate the discussion. Robin is currently the Director of Gender and Justice Initiatives at the Center for Court Innovation in New York City. In this capacity, Robin provides technical assistance and strategic planning advice to courts and communities who are interested in enhancing their response to violence against women and children by supplying best practice information, written materials, needs assessments, training, and consultation. So, Robin, thank you.
Thank you. Thanks so much. And I'm really honored to be working with everybody today. It's, very unprecedented times. And so I'm glad we can all come together and get more of this information out. So as you just heard about the Center for Court Innovation, we work with courts and communities, and I've been really fortunate over the years to work with King County and the work that they've been doing on domestic violence, but also we're joined by two of our national domestic violence mentor courts, Winnebago County in Illinois, you're going to hear from them, and Miami-Dade County in Florida. So we do a lot on court and community collaboration, judicial leadership, victim safety, and offender accountability. So I'm excited to be able to help with this today. So our next slide, we're just going to try and get through a whole bunch of things today. I know everybody has Zoom or webinar fatigue, so we're trying to, cram in a lot of stuff in an hour. So I'm going to keep this short, but we are going to hear from 3 different jurisdictions today about remote filings for criminal no contact and civil orders of protection, and obviously thinking specifically about intimate partner violence and animal cruelty. And hopefully we'll have a little time before the Q&A to just also talk about long-term how we see some of this remote work transitioning into kind of future ways that courts can enhance access to justice, and also for other potential crisis planning. So next slide. Since we're doing this remotely, we wanted to give the speakers and all of us a sense of, who's on the call today and what people are doing out there. So we're going to ask you to use that raise your hand function, and then my friends at APA are going to help us give the results. But the first question is, does your court currently offer online remote civil protective order process? If you could use your hand function to let us know. I think APA is going to let us know what those results are.
Yes, and I see that they are going up. Just want to give people a couple minutes, not minutes, but a couple seconds to get their hands raised. And the number is still going up. All right, so it looks about 30% of the attendees hands are raised.
Great, and that's helpful. And now we're going to ask you to do it one more time. Asking about online remote, either no contact orders, criminal protective order process. Is that currently happening in the current situation with COVID? We're going to hear from APA on this one as well.
Okay, we're saying at about 17% of the attendees have raised their hand.
Terrific. Thank you all for participating. It helps our presenters just have a better sense of who they're talking to and what's going on in all of your jurisdictions. So we're going to go to the next slide, and we're going to start things off today by hearing from presenters in King County, Washington. And to kind of save time, I'm going to let them introduce themselves and kind of give you a sense of their jurisdiction and what's happening there. So I think, David, are you going to start it off?
Yeah, thanks, Robin. I appreciate it. And it's great to meet everybody over the call. My name is David Martin. I manage the domestic violence unit for the King County Prosecutor's Office in Seattle, Washington. I'm joined today by my colleagues, Colleen McIngles, who is our Protection Order Program Manager, And Seattle Police Sergeant Dorothy Kim, who manages firearm and service work for the Seattle Police Department, is doing some really amazing and innovative work on e-service. So just for a little bit of background, for those who don't know, King County is not Kings County in New York. We're Seattle and about 38 other cities in King County. It's 2.3 million people. We have about 10 to 11,000 domestic violence police reports that happen every year, and thousands of criminal no contact and civil protection orders that are issued. Civil protection orders are really important to public safety and critically important to my office. We've been providing direct advocacy to the community, to thousands of petitioners, and you can advance the slide, for 31 years. We've been doing this in person in our courthouses, and we have a team of advocates who help people with protection orders. It's a big part of the work that we do with our courts and our clerks and law enforcement. We connect this work directly to a regional team that we have that examines all protection orders to see if firearms are present as part of a team with Seattle Police Department, our Sheriff's Office, and the Seattle City Attorney. And we partner with a large network of legal aid providers through a VOCA-funded partnership and also pro bono. I wanted to include a couple of photos, and one of our motivations, and the reason we've done this for so long, is the photo at the bottom is a hallway in our courthouse, and that's a hallway where a domestic violence, basically mass murder, happened decades ago, arising out of a family law and protective order case. So we had a horrible homicide happen in our home, in our building, and that has motivated our response ever since. A key part of our laws in Washington have to do with protection for animals in protective orders. That's our revised Code of Washington 2650-060, that courts may direct possession of the pet and have that be part of the terms of the order, and make sure that the critical part of that relationship is going to be protected. So we have a strong community and systems coordinated response. It's governed by memorandums of agreement. A lot of people are deeply involved in this whole process, but what we didn't have is we didn't have a remote protection order system. That's not something our court was very interested in. For a long time, we had been asking, and we started to pilot one in the fall of 2019, pre-COVID, with a local legal startup technology company in Washington, working with them closely. And it was something that we wanted to ground remote access with victim advocacy was critically important to us, and make sure it connected directly to this complementary system of response that we have in King County that we work hard to effectuate in regards to firearms and service. So I'm going to turn it over first to my colleague Colleen to talk to you about our remote program, and then to Sergeant Kim to talk about e-service. Colleen.
Yeah, you can go ahead and advance the slide. Thank you so much, David. We've been fortunate enough here in Seattle to have a lot of tech assistance and tech new startup companies, and a strategic partnership evolved with a new startup called Legal Atoms. And they originated with divorce filings, so family law, divorce filings, and basically developing a platform online that can help self-help tool to help someone through a questionnaire similar to TurboTax like platform, where it walks you question by question through a series of different required information that then basically generates it into a court form. And so similar with domestic violence, they were able to adapt the platform to domestic violence, and have been working with our protection order advocacy program, which is housed within the King County Prosecuting Attorney's Office, where we have about 10 advocates that are doing in-person services, but we wanted to expand our services to reach people that may not be able to make it into the courthouse physically, and or may want to work on this at home and then bring it to our office for consultation and review. And I think a big thing about applications with domestic violence is you always want to focus any sort of protection order around safety and safety planning. And we know that best practice for safety planning is when an advocate or the like is assisting someone with a coordinated safety plan. So if you want to advance to the next slide. This is our protectionorder.org website that we have up for our entire county. And computers are really, really great at answering simple, specific questions like, can I get a domestic violence protection order? Or how do I get a domestic violence protection order? But it's a much more difficult, I think, with computers to navigate, um, should I get a domestic violence order? That's where that key to advocacy really comes in, that coordinated safety planning and understanding lethality and risk that we know is so evident with protection orders. So when we entered in this relationship with legaladams.com, we really came with it with this mindset that utilizing tech as a tool, but understanding that it needed to incorporate advocacy, that it needed to be partnered with advocacy as a means to create greater access to our system. And then if you want to advance to the next slide. Our tech partners are really great at flowcharts. And so, and it's a kind of a visual, this idea of a partnership between technology and victim advocacy is really something that is new. And we found that we're not, we're able to create a better relationship and kind of holistically serve survivors better through not only in-person services, but providing this online platform. And you'll see that, folks seek out information these days through tech. They're Google searching, they're looking things up, trying to get information before having to walk in through the door to access services. So our thought is how can we utilize technology to get more information out when people are assessing, is this a good next step? And so utilizing Legal Adams, we're able to kind of get people started in the petition process. We're able to connect them directly through POAP, Protection Order Advocacy Program, for document review and follow-up. And we're also able to connect them with not only legal aid through that portal, but also we have a virtual pop-up clinic through our Seattle University is providing specific assistance in that petition section, in addition to what our advocates are able to provide, which has really changed how we've been able to respond due to COVID-19 and the restrictions of social distancing that we have upon us. And then once somebody files, we're able to get that streamlined directly to the court, really in a swift way, with really clean and clear forms that the court is then able to really read, they're not handwritten, and then enforce, and they're much more enforceable. And then we've also been able to partner with our Regional Firearms Task Force to review those. We have some specific firearm language, so we can get create that connection with our firearms unit much quicker. So we've really benefited from this, and also I think Sergeant Kim with the electronic service is going to talk a bit more about the work we've done there.
Yes, hello everyone. I'm Sergeant Kim with the Seattle Police Department, and I supervise the 4 detectives that serve court orders and follow up with any order to surrender weapons. So my detectives actually came up with this idea and developed the procedure for e-service. The first thing they do once they determine e-service is appropriate is they contact the petitioner, informing them that the order of service attempt will be made via email. They ask if they have any concerns or objections to service occurring this way. And then they also verify the email address and also get a sense of whether or not the respondent actually checks his email and is on his computer or on his phone doing so. From there, we contact the respondent via phone to set up email service. Again, this is just another layer of making sure we have the correct email address, the person is going to respond to it, and it's all part of our documentation to prove that we did serve it to the correct person. We consider recording this call if it seems like it's going to be problematic. And then we also have the email set up so that it has an automatic open read notification. And after all of that is done, we actually save the original email within our data system, the actual email, because if the metadata is needed in the future, then we'll be able to access that. Let's see. So on the actual email, the detectives list the cause number and then each of the documents that are being emailed. So this would be including the temporary order and then the petition. And we attach it to the email and email it to the respondent. We ask the respondent to reply to the detectives via email that they have received the court documents and also to list the court cause number on it. We've had some issues with respondents not being quite savvy enough to answer everything correctly in it, but we do have the read receipt, and that seems to be working pretty well. And then like I said, we save the actual email to the return of service for future access to the metadata. Then the detectives do the return of service and they attach the actual email that has the information in it. And then they also completely fill out on the return of service that they had emailed it and the email address that they had emailed it to. Yeah, and that is basically it. It's a pretty easy system, and I think we're doing a really good job of documenting the service and that we're serving the correct person. And then next slide. And this is just some of the challenges of being out there in the field serving court orders. And if we do have an order to surrender, obviously it's going to involve us being out in the field and then being in PPE gear and so forth.
And so Dorothy and Colleen, thank you both very much. And so that gives you a quick overview of King County's system. We're happy to provide any documents or anything anybody wants to know, or if you want to reach out and talk to us, we're always available.
Great. Thank you all so much. And I'm sure there's going to be questions, which people can feel free to put into the chat box and we'll get to at the end of our presentations. I also want to make one note that the handouts, and there are some terrific handouts from all three of the jurisdictions featured today, are in your toolbar, and you also were emailed them earlier, so please take advantage of those. And now we're going to turn it over to the team from Winnebago County, Illinois. So Judge Wilt, thank you. Yeah. Judge Wood, I just want to make sure you aren't muted still.
Now can you hear me?
Yes.
All right, well, we'll start over. Sorry about that. I'm Randy Wilt. I obviously screwed up from the outset here. Sorry about that. Winnebago County is in north central Illinois. We have about 300,000 residents. We have farming and manufacturing as our leading industries, and poverty has been a problem. So there are those types of economic issues we face. Domestic violence is a huge problem in our community. Our police tell us it is the leading cause for police calls for services. Last year, we handled 3,223 petitions for various types of protection orders. Now, we have both civil and criminal protection orders of various types. We have domestic violence orders of protection, which you're probably familiar with. We have civil no contact orders where the petitioner has been the victim of some sort of a sexual assault. And we have stalking no contact orders where somebody's being harassed by an individual, even if there's not an intimate partner relationship. Now, whether something is civil or criminal has nothing to do with the type of petition that a person files. If at the time the petition is filed, there is pending a criminal matter that's related to it, it will be dealt with as a criminal order protection. If there's not, it'll start out as a civil matter, but if later on the state's attorney's office files a criminal charge, it can then be converted to a criminal protection proceeding. If it starts out as a criminal proceeding and then later charges are dismissed, then it will be converted to a civil proceeding. Now in Illinois, there are key differences that are very important. For example, if I enter an emergency ordinance civil matter, the hearing, the contested hearing, the plenary hearing has to be no more than 21 days down the road. If it's a criminal matter, there is no statutory time period. It is in place until the judge considers the request, what is referred to as a final order. If it's a criminal matter, our state's attorney is obligated by statute to represent the petitioner, not so in a civil matter. If it's civil and the final or plenary order is entered, it's good for 2 years. If it's criminal, it's good for 2 years beyond the end of any sentence that might be imposed should there be a conviction, including a period of parole or supervised release as we refer to it. Now, if you'd switch to the next slide, please. Now, how we got ready, we already had for the last several years in place an after hours order protection process. It was triggered by a call to a police officer who then referred the person and usually transported the person to a local service provider who provides services for victims of domestic violence. And then they would help them prepare the petition. So by its very nature, our services were limited to domestic violence orders of protection tied into criminal cases. So when we went into our developing a remote process, we had to come up with something that was a lot broader that would encompass all types of protection orders, both civil and criminal. The process had to eliminate the need for police contact. The process had to eliminate the need for a service provider to prepare the petition. And the process had to allow for an individual to remotely file from the safety of their own home. We started by creating a very small work group, 3 people actually, besides myself. We have Nikki Tickner, who you will hear from. We had Robin Bach from the Circuit Clerk's office, and we had Kim Ackman from the Trial Court Administrator's office. I can't even begin to tell you what miracles they worked. In 3 days, they came up with an idea and resolved all the problems and had it ready to go. Some of the problems they had to confront are, first of all, how to fool a computer program, because the program that is used requires the petition to be signed, and an individual filing remotely cannot sign a petition. So they found a way to get around that. There had to be instructions prepared both in English and Spanish for our court's website to help people understand the process and understand what type of protection order would be most appropriate for them. There had to be instructions on what website to go to actually prepare the petition. And there had to be training for our judges. Nikki prepared and did 3 different Zoom trainings so that all of our judges were trained within a period of 2 days. So they were able to go ahead and handle these matters. And she prepared a bench card, or what I call a cheat sheet, so the judges could have available to use in doing this. And as you'll hear now, it says on here that there's a video being prepared. It's actually done now. And I think Nikki will probably talk about that. Kim Ackman then was responsible for assigning judges to do these types of cases. During the slowdown here, not every judge is working every day. So a work schedule assigning specific judges, specific days was established. Those judges hear both walk-in orders of protection and remote petitions for orders of protection. And since all of our judges are trained, they can have backup help available if necessary. This is working for us. I guarantee you this is going to go forward in the future after things come back to whatever normal is. I mentioned the number of petitions we did last year. Since March 20th of this year through the end of April, 30% of all petitions filed were filed and processed remotely. That equates to over 1,000 petitions a year that would be filed that way. So that's significant enough to go ahead with this. So that's kind of the background information. I'm going to turn this over now to Nikki Tickner, who will explain to you the process in more detail. So if you go to the next slide, please.
Thank you, Judge. Hi, everybody. So this slide really just walks you through what the process is for a litigant to file a order of protection remotely. And as Judge Will indicated, we really had to adapt the system to work for us, as the system was created on the premise that someone would always come into the courthouse after they submitted the paperwork electronically. So we were able to adapt this so that everything could occur remotely. On this slide, you can see we direct people to our court's website. There they can find all the instructions that they need to start this process. And it will direct them to the actual website where they can begin the paperwork. Similar to what King County was saying, it opens up a web application that just walks people through each question, and then on the back end spits out the court paperwork. One thing we continue to talk about through this process is just making sure that this was accessible as possible to people. We understand people learn information different ways, so we have written instructions on our website. As Judge Wilt referenced, we also now have an instructional video, which I think you received a link for on the email that came out prior to the webinar. So once the petitioner completes the process, you'll see we'll move on to box 2. Our clerk's office then collects information from them. So the petitioner does have to reach out to the clerk and say, hey, I've just filed this order. The clerk then gathers information, stresses that the court will be calling them back. So we need to have a safe and reliable number to reach them at, and then gives them a period of time where they can expect a call back. The judge then has access to the petition both online and a hard copy. They contact the petitioner, they put the petitioner under oath, and sign actually in place of the petitioner. So we agreed that judges could place the petitioner under oath and then sign on the petition that that person has been sworn in telephonically. The process then occurs like it normally would for any emergency proceeding. The paperwork goes back down to the clerk's office. The petitioner is given the option of picking it up or having it sent to them. And then it goes out for service to the respondent, just like it would in normal non-remote times. Next slide, please. So if people want to file with the use of attorney, so most people are self-represented litigants, but some people are represented by counsel. Attorneys have the ability to use this technology just like anyone else would. And what we decided is that if attorney filed on somebody's behalf, that the judge then would reach out to the attorney first, talk to the attorney about how they wanted to proceed, and then move forward from there. The judge can then reach out to the client themselves, or they can have the attorney kind of do a conference call with the judge for the emergency proceeding. Advocates are crucial in this. We understand that however people are filing orders, they always have the right to an advocate. And so if people choose to file remotely, they could reach out to our domestic violence service provider, Remedies, and ask for assistance walking through the program or talk through any sort of questions that they had. Also, advocacy can happen on the back end. So if a judge knows that someone filed on their own remotely from home or a different space, they then are encouraged to remind that petitioner that advocacy services are available, that they should call Remedies to connect with someone for preparation of the final or plenary hearing. And also our courthouse does remain open for essential services. So if a survivor or petitioner felt that remote filing is not the best option for them, it's not safe, or they don't have good access to technology, we still do have in-person advocacy through our Domestic Violence Assistance Center. That would be an option for people as well. And that is us, Winnebago County. Thank you.
Thank you, Nikki. And Nikki is the project director for that, for their domestic violence mentor court, and it's a huge resource. So thank you, and obviously thank you also, Judge Wilt. And I just want to encourage everybody to take some time to look at that video. I found it really informative, and I think will help other communities as they work on this. So last but not least, we're joined by another one of our mentor courts. From Miami-Dade County, Judge Kelly, please take it away. Thank you.
Thank you so much, Robin. And it's been wonderful listening to the other panelists and the wonderful ideas and programs they're implementing around the country. Miami-Dade County is comprised of approximately 2.8 million people. We have both an urban and a rural population. We have a very large immigrant population, and approximately 65% of our citizens speak a language other than English at home. We currently have a setup where we have an integrated domestic violence court. So we have the civil restraining order process, and we have 5 different types of civil restraining orders: domestic, dating, repeat, stalking, and sexual violence. And we also now have begun in our division to be hearing what we call risk protection orders, which are the red flag orders. In addition, we have concurrent jurisdiction over misdemeanor domestic violence criminal cases. And so that's basically the setup of our domestic violence court. We do operate out of 5 courthouses throughout Dade County, north, south, east, west, and those are geographically spread out, and that's great for access to people. In starting all of this, again, it was kind of just like I heard from Winnebago. There were 3 people, and I know one of them's on the line. Her name's Adria Villaverde, and she's our domestic violence director. And she and I and another administrator, Crystal Geraldo, started, the 3 of us, as soon as this happened, and sat down, and we were under the directive from our Chief Justice as well as our Chief Judge to go out there and make sure that we were, getting our systems up. These were mission critical cases, and we were directed to do what we needed to do. So the first thing that we had to do is set the goals of what we were going to try to do. And our court really did not have much of anything in terms of remote operations. And our goal was to transition our court from in-person operations to remote operations, knowing that we had to ensure that we're giving people proper notice and opportunity to be heard, due process, and procedural fairness. Also, because our cases involved domestic violence and other forms of violence, we always had to ensure that we took measures to ensure victim safety. So we started off with a small group. We were told by our court that we were going to be using the Zoom platform, and we began. And from there, we added additional individuals. We came up with a tech committee where we added three additional judges. We added a judicial assistant and a case manager, and their job was to help all of us get up to speed and learn how to do remote hearings and learn Zoom. Our court, our circuit also was at that time beginning to provide training. So every morning there would be a Zoom training, and every afternoon there would be a Zoom question and answer section. So in addition to that, our domestic violence division, we set up multiple trainings. We invited everybody that would be working with us, all the judicial assistants, all the bailiffs, case managers, interpreters, everybody was invited on the civil side. And you can advance the next slide if you'd like. So we practice and finally we did mock trials. We had judges sit in and watch other judges. We had everybody sit in and watch so that we could learn from each other and share best practices. So our civil orders of protection, we still are not remote. We are operating out of those 5 courthouses that I mentioned previously, and victims have to walk in. The clerk's office did not have the capability to do remote filings, and so they set up social distancing barriers such as tables to prevent the contact between the clerk's office and the victims coming in to seek protective orders. So we're behind. That being said, the clerk's office would utilize the phones. They would be speaking to victims over the phone, taking their information, processing their paperwork, and then sending them to the judges for signature. The one thing we did have going for us at the time that COVID hit was we were already doing remote signing of injunctions. Our judges are on duty 24/7, and we remotely sign through an application called Smart Forms, which is an application that allows us to sign our orders remotely and send them back to the clerk's office. And then the orders would be provided to the petitioner in person by the clerks. So the clerks would then send these orders of protection to the sheriff's office for service. Our good news is that our Supreme Court, through our Justice Management Council, has been working on a system called Access to Justice. I think it sounds similar to the Legal Adams program that we just heard about. And it's a remote filing system. And it's an easy to use platform that assists petitioners by asking simple questions and then populates the petition. And we're very excited. It has already, the forms have already been put into the platform. They are being tested right now. And we are hoping that very soon we will have the opportunity to have the remote filing. And we will be using the coordination and cooperation of our victim assistance centers to utilize these programs to assist petitioners filling them out, as well as our legal aid and other legal services organizations. Because as we spoke about, somebody mentioned, the connecting victims to advocacy services is so central in the civil and the criminal protective order process. We currently are holding all of our hearings remotely. There is nobody going to the courthouse now. Our civil orders are completely up. We have interpreters. Our clerks are not attending those, but we are sending our evidence to them, which has it's created a few challenges, but we're working through it. We have a court reporter that logs on and presses a button to record our cases, and we're also using the Zoom record button as a backup. When we have the need for interpreters, it's slowing our cases down tremendously. Previously, we would have anywhere between 16 and 24 cases heard per judge per day. We are down to 4 per day, and that's all that we can handle. Next slide. On the criminal side, the only way in Florida that you get a criminal no contact order is after an arrest. So all of our criminal no contact orders, just for education, contain a no firearms, no contact, and an ability to go get personal belongings with the police. We very often use the GPS and no alcohol provisions in the order. But so the way that people get a no contact order is after an arrest. We have a bond hearing, a first appearance hearing. In our state, all DV defendants have to be held overnight and appear the next day at the domestic violence bond calendar. And we are now up and running via Zoom. So the Department of Corrections was really wonderful in giving us separate space at the jail and where they would bring the domestic violence defendants. And they also supplied a computer where we could, which would facilitate the defendants being able to have their first appearance hearing. We set up so that the public defender and private defense counsel will have private Zoom sessions with the inmates an hour and a half prior to the calendar. That gives them ample opportunity to go over whatever they need, ask questions, and give them advice before the first appearance calendar. Everybody is present via Zoom and everybody is present remotely. The judge, the state attorney, public defender, any private attorneys that come in, clerks, interpreters, corrections, and our pretrial release department. So everybody is in their own separate space appearing remotely. So the way that it works is prior to the hearing, the clerk of courts will email the judge the calendar, the arrest affidavit, any prior criminal history. That would be our statewide criminal history, as the state attorney will provide us with the NCIC at the hearing, and a case history sheet and stay away orders. And then after the court hears from both sides, we'll set the conditions of bond and send the paperwork to the clerk's office, who will forward it to pretrial release and the jail. So we are doing most of our operations, our criminal operations, remotely now. It's worked out very, very well. Obviously, we don't have jury trials. So that's kind of the overview of how we got there. One really exciting thing, which I didn't mention since we are discussing animals, our civil injunction orders provide that we are allowed to provide any other relief necessary. And we have used that through the years to provide relief and to address the issues of animal abuse and who will have quote unquote custody of the animals. This year, our we had a bill to specifically include the abuse of animals and addressing animal welfare that has passed our House and our Senate. It is in front of the governor for signature. So we believe that animals will be specifically included in our orders of protection going forward.
That's great. Thank you so much, Judge Kelly. That's fantastic. I guess we can go to the next slide. I just wanted to ask one or two questions before we open it up to the chat box questions, because I'm sure there are questions for all of you in there. I just wanted to ask again, I know Judge Kelly touched upon this, but giving an opportunity for the others to talk about sharing documents and evidence in these remote situations. We've heard from around the country on other calls that this has continued to be a challenge for folks. So does anybody, I know Judge Kelly, you mentioned that you're doing that ahead of time. And if you could explain that a little bit more, and perhaps if Winnebago and King County have any tips on that, that would be helpful.
Robin, could you please repeat the question that you asked? I apologize.
Sure. No, I was just going to ask for a little bit more detail on the sharing of evidence and information and how you're doing that remotely, because we've heard from many of our jurisdictions that this continues to be an area that people are struggling with, of getting the information and sharing that evidence.
Yeah, well, so that is obviously an issue that we had to address. So we set up on both the civil and the criminal side designated email addresses, court email addresses, where evidence would be submitted prior to any hearing. We would have the opportunity then to share it with the other side. I mean, obviously the issue comes as the judge then, and in Zoom, what we do is we use this screen share function, and any evidence that has been submitted for introduction would appear on the screen, and we would allow both sides to then make arguments as to its admissibility. This works great when you have a bench trial, but we haven't, as I don't think any jurisdiction yet is doing jury trials. We will have to work out something different when it is time for a jury trial, because obviously if the evidence is not admitted, it should not be up and allow the trier of fact to see it. So because the judge is trained in law and evidence, we're disregarding that which is not admitted.
Thanks. And do our other jurisdictions have a different type of procedure that they've been utilizing remotely? I don't know, Judge Wilt or David, that want to add?
Well, this
I'm sorry, go ahead, Judge.
All right, thank you. This is Judge Wilt. I actually unmuted my mic this time. In terms of sharing documents beforehand, since our proceedings are for the most part very quick, have to be taking place in just a matter of days, the attorneys are obligated to share amongst themselves, and then they can send copies to the judge. But as was mentioned before, just because they share it with the judge does not mean that the court considers it unless proper foundation is laid. But at least you're on notice of what type of information they're going to be trying to admit. But that's pretty much the way we handle it here.
Thanks. David?
So I'll ask Colleen to address this. We're an affidavit-based system, and one of the real benefits of the Legal Atoms and the newer technology is we're able to attach all sorts of documents, screenshots, what have you, into the upload. It's very easy to use. And this is in the later technology that it sounds like Miami and others are doing. Attachments are very practical. And Colleen, I know this has been a real benefit to our practice because we had challenges getting this information in before because it was all contained on people's phones or was contained in social media, and getting that into the courtroom environment for primarily pro se litigants was a real challenge.
Mm-hmm. Yeah, and they're able to, because it's affidavit, they have to submit that electronically beforehand, but Legal Atoms has created a way for it to be very streamlined and easy to upload, and then it labels everything, timestamps things as necessary for evidence purposes for pro se litigants.
That's great. That's really helpful. And then I just wanted to ask one more question that's a little bit more about the criminal no contact order or criminal orders of protection, depending on what they're called in different jurisdictions. But we've heard some challenges arising out of victim notification. When courts are open and kind of doing business as usual, often victim advocates or victim witness coordinators are present and are able to hear what's happening in those arraignments or bond situations, and then getting that information to the victim quickly. And now, obviously, things are a little bit more challenging. So I'm just curious if people want to talk about how they've been addressing that to make sure that victim notification is happening in a timely way. I don't know who wants to take it, or all of you.
Well, I'll just say two things briefly. Yeah. Nikki, go ahead.
Okay. I'll keep it short. So whether it's a criminal order of protection or civil order of protection, petitioners are able to sign up for an automated order of protection text notification system. And so by inputting their phone number into that system, they do get a text saying that their order of protection has been served and is active. As far as conditions of bond, our state's attorney's office advocates are still working with victims and survivors and are able to communicate with them about any sort of conditions that are put on an offender through the court.
And I'd echo that. I mean, we use Vine as part of it, but I'll also say the reports that I've gotten across my jurisdiction and from my system-based advocates is we have better contact with victims now because of stay-at-home orders. They're deeper conversations. It's been one of a kind of a strange benefit of this practice. Our court is operating not using Zoom and Superior Court, but they're open conference calls. So we have victims who are able to call in with their advocate in consultation with the advocate, usually by text or some other means, to then address the court regarding no contact order or just listen in on the proceeding. So a court will have an arraignment calendar going. There will be, hundreds of people on a conference call, and the court will call the case, and then people will be allowed to speak at that point. We also very much front load our advocacy to what we call first appearance and other things in doing outreach. But I think that's a critical piece in all of this, is making sure you're connecting early in these matters.
Great. Thank you all so much. That's great information. So now I'm going to ask my friends at APA who have been monitoring the chat to let us know some of the questions that have been populated there.
Okay, thanks, Robin. And thank you all for the excellent presentation. This is such useful information. So thank you so much for your time. So again, you can use the GoToWebinar toolkit located on the right-hand side of your screen. And as we mentioned, we do have a large number of participants. So if we're unable to answer your questions, please email us at webinars@apainc.org. Okay, we did get a couple of questions regarding e-service and if there have been any prosecutions for violation of electronically obtained and observed orders, and if the court has challenged, or if there has been e-service challenged in court.
So I'll answer that. Well, I'm sorry, Dorothy, did you want to address?
No, go ahead.
Well, we can do this in concert. I mean, so far, I mean, e-service has been happening for, a couple of months now. And with the first challenge was overcoming what our statutes was requiring us to do, which is personal service. And we've tried to make that work. And now we're in a process that a lot of people are very interested in e-service. And it's been a good practice that Dorothy and her team have innovated on. The difference in the civil side of things is, right, you have to prove personal service in many jurisdictions. On the criminal side, I just need to prove knowledge. And I don't think there's anything magical about police driving around a jurisdiction and handing somebody a piece of paper and us having to prove knowledge in that environment versus Dorothy and her approach of doing e-service and having a response on that. So we haven't had prosecutions go because our criminal system, like many right now, are kind of at a standstill waiting for proceedings to pick back up. But I've personally charged many cases that involve the orders that Dorothy's group has served on, and we haven't had a problem on that. We haven't received challenges so far. They're pending matters. One involves a very serious attempted murder that happened in my jurisdiction. We don't foresee difficulty in proving knowledge in those matters because of the good practices that Dorothy and her team have done. Dorothy, I don't know if you have any concerns about the way that service is operated in the field for you.
No, I think how we're doing it is great. We're often able to serve the orders within an hour of it being issued. And so I believe that is better safety for the petitioner.
And we'll send out, I mean, we created my office, the Seattle Police Department, the King County Sheriff's Office have guidance that we sent out to law enforcement statewide, and it's been adopted statewide in Washington about good practices for doing e-service. And we've had really great response from law enforcement and from courts about this practice.
Can I also just mention a part of what Dorothy has done with the Seattle Police Department from an advocacy perspective is that they're having real-time conversations with petitioners doing electronic service. And so that's made a huge impact for safety, and the quick turnaround has, when she says it's been within an hour, that's huge, especially when you have a coordinated safety plan.
Okay. So for the next set of questions, there were a lot of questions that came in about victim safety and security, especially for those who may still be at home or in the same home with his or her abuser. So what steps have you taken to ensure safety and also the security and feeling safe? I'm talking about some private issues virtually.
This is Nikki. I can touch on this quickly. So as Judge Wilt referenced, when we started training the judges about this, how this would go, one thing we stressed is to be mindful about safety and that we don't have, there's not that controlled environment of the courtroom. And so we don't know who's around when the court is making these callbacks. We don't know who is in the home when the petitioner is filing this. And so we're always operating with safety in the forefront. But I would also say, too, that we have to remember that survivors often know their own level of safety, and we have to trust that if they chose to proceed with a remote procedure, that they felt like that was the safest and best option for them. And so I would just encourage everybody to work with your judges and your clerks just to make sure that they're trained to keep safety in the forefront and that they're trained to ask questions when they're asking for information. Is this a safe number? Is this a safe callback time? So that survivors are aware and can make the best decisions for themselves.
Hi, this is Judge Kelly. Couple other practical things that we instituted is that when petitioners were calling in for their civil hearings, the JAs were instructing them, bringing them from the waiting room into the actual courtroom so that they could rename themselves and change any identifying information such as email address or anything like that. And additionally, the JA would speak to them about making sure that their background was safe, so that their background did not give away perhaps a confidential location where they were located, and would also give the litigant the opportunity to learn how to change a virtual background. So those were just two practical things that we did, but we're definitely cognizant of the inability of many victims to leave at this point.
Okay, and another set of questions we got were, how do you extend protective orders that are set to expire?
Well, this is Judge Kelly from Miami again. We had an administrative order from the Florida courts extending all the timelines and allowing us to continue those cases and suspending speedy trial rule. And so we had a first 30-day extension, and then our Supreme Court issued another order that allowed for another 30-day extension. And our statute allows for extensions for good cause in addition. So those are the mechanisms and the background as to how we had the ability to extend.
All right, this is Judge Wilt from Illinois. Our statutes also allow for extension of emergency orders for good cause, and obviously the certain pandemic right now would be a good cause to do that. So our judges are doing that unless for some reason they feel there's a really, really good reason that the hearing has to take place right now, and then we have provisions in place for the hearing to take place. And I would also note that if it's a criminal protection order that's being sought, the statute actually allows for the petitioner not to appear for what's called a final hearing. The prosecution who has to represent them on the protection order can represent them. As long as they indicate they've had contact with them and they're intending to go ahead, the matter can proceed or be extended by agreement if that's what they want to do without the petitioner being present. And if they are present, we have provisions in place for additional security. But ultimately, other than the no contact provision of this, other remedies that are involved in a criminal protection order, there has to actually be a hearing where they're supposed to be present. We can't just proceed on affidavits for those types of things.
Okay, so we have hit the 4 o'clock mark. I want to say thank you so much again to ALDF for your support and making this webinar possible. Thank you to CCI and our wonderful speakers for sharing with us your efforts and all that you do to protect victims of crime. And thank you to our webinar audience for being in attendance today. All previous APA webinar materials and recordings are available at no cost on our APA membership website, and we will be notifying you via email when these materials become available and how you can access them through a temporary membership. If you are a current APA, prosecutor, court, law enforcement, or criminal justice partners member, you will have automatic access to webinar materials once they are available online. Again, if you have more questions for the speakers, please email us at webinars@apainc.org. That's APAINC.org. And we'll be sure to forward them along. Thank you for attending and have a great day.